name is Steve Schwartz. I run the LSAT blog. I also host the LSAT Unplugged YouTube channel and podcast. Herb, you want to introduce yourself?
Sure. Although you've hit some of the high points, Professor Ramy, Suffolk Law School. I've taught there since 1997. I used to teach in the legal writing department, the LPS program at Suffolk Law School. Today, I direct our academic support program, and that really has two basic functions. One is to help all incoming 1Ls acclimate to life in law school, because it is not what life was like in university before you got here. And the other part of it is working with students who might struggle at some point when they're here in law school. And a surprisingly large percentage of students struggle at some point when they're at law school. That shouldn't be surprising because it's something new. And we have a fairly large department, because we're a fairly large law school, to give folks that guidance that they might need in order to get over any hurdles that they're dealing with.
That's incredibly important. I've heard a lot that 1Ls entering, they have some struggles oftentimes the first year, the first semester. Why do you think that is?
Yeah, a great question. And really what a lot of my book is dedicated to is that idea. The first part, I think, is simply the rigor of law school. With the exception of the occasional engineering student or medical doctor who I've had come to law school who understand what a rigorous education is. I'm an English major, so I don't want to be insulting any of the arts out there, but as an English major, coming to law school is extremely different in terms of how many hours you would spend studying. It has to be in the neighborhood, one of my friends put it, 8 hours a day studying, 8 hours a day sleeping, 8 hours a day doing whatever else is that you want to do. And that's 7 days a week. And that's not when exams are coming up. That is week one. If you're not at a 50-plus hour way of studying, and that includes pre-class and post-class, you will struggle in law school because your classmates are doing it. The other part of it, I think, that folks struggle with is mastering what we call mastery of the gray. You know, you come into law school understanding that I'm going to need to learn the law, need to learn principles of law. But as I say to my students, you know, it's high school level that I teach you. These are the elements of what the tort of battery is. These are the elements of the crime of murder. Memorize those words. But applying those concepts to factual scenarios that you've never seen before, and being able to recognize that those scenarios generate those problems is a difficult skill to master. And on a law school examination, the notion that there may not be an absolute correct answer. Much of the time on the more thorny problems we give you, your job is to expose the reader to both ways, or even more than two different ways of looking at the problem, and arrive at what you believe to be the best conclusion. And the best conclusion has to include a discussion of the alternative approaches. That's very difficult to master.
So considering all the possibilities, all the alternatives, things aren't black and white.
Yeah, absolutely. And that's what our jobs are as attorneys. You know, we're very risk averse. Business folks are the opposite. They tend to be risk takers, but lawyers tend to be very risk averse. Our job is to advise, for example, a business client and tell them, these are the pitfalls that I see. Ultimately, you have to decide whether you're going to go forward and do whatever you're thinking of doing. But I can tell you here are the relative pitfalls of going forward. Here's how I rank them in likelihood of occurring. And here's what the biggest problems that I see are in the future for you.
I love it. As you were talking about this, I was just thinking of how it relates to the LSAT a little bit, where things are not clear cut. And of course, many of the arguments on the LSAT contain significant flaws or gaps in the reasoning. And our job is to point out, hey, let's consider these alternatives. Let's consider how complicated things could actually be, because the world is pretty messy. And most of the LSAT and most of law is not conditional reasoning. Or at least not simple conditionals. Rather, there's lots of things to put out there.
Yeah, absolutely. You know, in a typical law school examination, we'll give you a lengthy story, a fact pattern that you have to reason your way through. And it's impossible for us to expose you to every sort of fact pattern that you will ever face in your life as a lawyer. So we're giving you these thorny problems so that you can see and explain to us what you think an approach would be to resolving it. And oftentimes, and this is really my upper level students in my advanced writing course struggle with, that the final answer might be a 80% conclusion. You're 80%, 75% confident that that's how the court will resolve the matter. That's what you should be conveying in your writing, is that, hey, this is a reasonably strong conclusion, but the alternatives have some merit as well. And that's why many cases never go to trial and resolve well before that, because both sides recognize that there are some weaknesses in their case, and let's settle things before we ever get to trial.
It's funny. I was just saying the exact same thing earlier today when it comes to the LSAT writing sample. How the
Right.
LSAT writing
Yes.
sample, they want you to recognize that it's nuanced and it's not one option clearly being better than the other. If you say option A is great and option B is terrible, you're failing to consider that,
Right.
there are pros and cons to both options.
Right. And in our, in writing at the law school level, one thing I try to point out to students is, again, we'll be giving you a lengthy fact pattern. Almost every fact in that problem is meant to be in your answer at some point and discussed. And that's where I think a lot of folks struggle. They'll mentally discard information. So, oh, that's unimportant for X reason. Boy, that would be beautiful if you put it in your answer and explain to me why you thought that that was unimportant. And if you did, you would get a much better score on your exam. Or maybe even if you put it in there, as you begin talking it through, you'd recognize, wait a minute, that's actually more powerful than I first realized. And the idea is in the writing of an idea out, you begin exploring it more deeply and more thoroughly understand the pros and cons of a position.
Nice. Thank you for that. I want to circle back to this, but first I want to just acknowledge that I was pretty impressed the second we joined this call before inviting everyone else in with the tech. Like the video
Sure.
was good, the audio was good. That doesn't always happen. Sometimes people I have these chats with, they'll come in, we have to kind of figure things out for a bit. And so I'm guessing that you, as we discussed earlier, that you've gotten quite proficient in it, or at least competent at Zoom as law school transitioned online this past spring. And so I'm hoping you could share a bit more on what that experience was like this past spring and then what you're looking or expecting for the fall.
Yeah, and I would use the word competent. I'm not so quite sure about
Yeah.
proficient that yet. I'm still trying to work through chat breakout sessions in using Zoom. So it really was, I think, for a lot of us in March, it was a trial by fire. And we were fortunate a couple of different ways. Something we chatted about a little while ago, that we have a large evening division. We're used to posting content. We're used to be using technology. So that made things a little bit easier for us. Also at Suffolk, we had been on spring break when it was announced that we would be closing down the building. I think it was on the Tuesday or Wednesday of spring break. So we also all had a few days to ramp back up before classes began. Now, a few days is not a lot of time, but it was a lot more time than I think some schools had. Some schools had to shut down an extra period just so that they could try to get things off the ground. It was, I think, difficult for faculty and students alike. And from the student perspective, I think it was difficult being being invisible in a classroom, not feeling like their voices were heard quite as much as they were accustomed to them being heard in a live classroom. And over time, the faculty became much more proficient at finding ways to acknowledge students during class. One thing I've been discussing with my colleagues, I help run our teaching assistant program, is that utilizing teaching assistants is a fantastic way of engaging in a Zoom conversation, because the teaching assistant can monitor the participants, can do polls, can let you know what the questions are. So opposed to sitting there and speaking for a half an hour and saying, now, do you have any questions? The questions can occur a little bit more organically. So a lot of us were learning those things on the fly during the fall, during the end of the spring semester. For the students, one thing I talked about quite a bit with individual students on one-on-one sessions with them is, this has become a job now. You have to recognize, like I did several years ago, I had a sabbatical, and I realized I was going to bed later and later and getting up later and later, and nothing was getting done. You need to get up when you normally get up. You need to get in front of the computer when you normally would get in front of the computer, or even earlier because you're not commuting now, and start your work day at 7:30, 8 o'clock in the morning, and just get into that routine. And then I think that was difficult because everyone's routine had been shattered. We weren't going to the same coffee places in the morning. We weren't getting on the commuter rail in Boston or the subway or the T or wherever it is you travel. You weren't getting in your car. So those routines were all changed. And suddenly we're all sitting in front of our computers, a lot of folks, not the professors, but a lot of folks in pajama tops and bottoms, or at least hiding the pajama tops, but wearing their pajama bottoms, and a lot of sweatpants were worn. So I think that was difficult, is figuring out the ways to be productive in this new environment.
A lot of useful tips there. It's nice to hear your experience as well. I'm wondering what kind of support students might expect to get if law school is partially or entirely online in the fall.
Yeah, so we're working on those issues right now. Again, we worked through a lot of things this past spring at my law school, and I speak with colleagues from across the country, and we're all working through those issues right now. The first step is deciding what everybody's going to do. And that's going to be different across the country. Harvard University announced a little while ago that they were going to be completely online. I think the California state system is going to be completely online. In contrast, some other schools have announced, nope, we're going to be live. So if you're going to be fully live, there are some issues involving exposure to the virus, in terms of testing, in terms of mask wearing, all of those issues that are going to be in place that don't affect people who are going to be fully in a fully online modality. So those are things that need to be aware of. But in terms of the online learning, folks are going to get training on how to use Zoom or whatever platform your school operates in. The professors at my school are receiving training. I just went through 2 or 3 different training sessions on how to record content, how to I know how to record content, but to use my PowerPoint presentations, to have those PowerPoint presentations automatically have my words appear across the bottom. So for students who are hearing impaired, they can listen, they can watch the words as they're being spoken. So learning how to do a lot of different things well before any of you get into the building, well before any of you are doing anything online. So a lot of that is happening. Some of the things that students might miss out on if they're not in the building are those organic encounters that you see, those meetings, those chance meetings with a classmate, with a professor. So we're figuring out ways to make those things happen. As Director of Academic Support, I'm going to be hosting gatherings of students who want to get into a study group, who want them to discuss outlines, who want to discuss their towards class with their classmates. So we're going to be doing things, alternative ways of engaging in the same sort of conduct that we did when we were going to be live.
I'm really glad they're thinking about that, because that is incredibly important, the social aspect as well, to replicate as much as possible of the experience, because law school is difficult, as we said, and to have a community of students who can support each other to recreate study groups and such,
Absolutely,
I think adds a lot.
Absolutely, and as I said, I'm not entirely positive what we're going to be doing at my law school yet. We're going to be meeting on Thursday as a faculty, and I think we're going to finally resolve at that time. I expect that it's going to be some sort of hybrid approach where we're going to have some live and some online, but we're really committed to doing live as much as possible for the first-year students, recognizing that that's an extremely important part of the law school experience. And I expect that a lot of schools are going to be doing the same thing, understanding that that's the most difficult students to give the live experience to, because if you've been to law school, you recognize in the upper level curriculum, I might be in a classroom with 20 other people. It's relatively easy to do that live and put it into a larger classroom and have social distancing. Our large classes are 100 students sometimes, or close to 100 students, and our rooms accommodate 110 or 115. So it's going to be very difficult to get everybody in a single location. So we're going to come up with some creative solutions if we go that route, to make sure that we maintain social distancing, that we have the health of our students really at the forefront of what we're doing, but also maintain a strong and rigorous academic experience for them as well.
Nice. It sounds like you're really doing your best with that and coming up with some creative ways to make it work. I could imagine like one room being live, one room having a screen, similar to like a spillover room that you see in conferences and such all the time. So
exactly. Yeah, that notion is being explored. The notion of, if you have a class on Tuesday, Thursdays, Tuesday, that half of the class comes in live and the other half is online. On Thursdays, we switch it around. Or we take a class that would normally be 100 students. We split it based on who wants to be live and who wants to be in the building, and we teach it that way as well. There are a lot of different things that are rolling around, and that's not just my law school. Again, these are from conversations I've had with my colleagues from across the country.
Right. I imagine they're all pretty much in a similar boat.
Yep, absolutely. Absolutely.
Related to that, I got this one question in the chat here from Evan, and folks can feel free to keep submitting more questions as well. Evan was asking about a potential drop-off in the number of students registering or matriculating this fall because maybe they don't want to do the online thing or there's too much uncertainty in the world. And so I'm wondering how a smaller school like Suffolk might mitigate any financial fallout from this, how it could affect admissions either for the cycle just ending now or the cycle that will begin this fall for those starting fall 2021.
Yeah, so in terms of the year that we just completed, nobody dropped out really. Folks continued. Again, we were doing everything online, so there weren't those issues. And by then, students had finished 2/3 or 3/4 of the year, so people really weren't leaving. The coming year, I can tell you, we were wondering what's going to happen. At this time, enrollment is still very strong. And I think that that's due in part to the current economy. We tend to see in certainly law schools and MBA programs a large spike in applications when the economy is relatively weak, because the opportunity cost of stopping whatever you're doing and going to law school isn't as great. If you're making $200,000 a year in whatever your job you're doing, or $100,000 or whatever doing a job, and leaving that to go to law school, you're leaving a lot on the table, incurring debt at that time and not making any money or not moving a career forward. If you are unemployed, if you're underemployed, if you realize you're stuck in a rut at your position, then this is the time frame that a lot of folks, and that's we've seen historically for certainly as long as I've been in legal education and for many decades before that. And every time the economy worsens or gets weaker, we tend to have a spike. So that may be offsetting some concerns that folks have in terms of the issues involving the virus.
Yeah, no, that's fair. And that's pretty much matches my understanding as well. Like things might be uncertain for this particular, entering 1L now, but the other question is, what else are you going to be doing? It's not as if the job market's that great. Do you really want to delay everything by a year? So
right. No, you read my mind. You read my mind on that, because I was thinking about that today. And again, for folks who decide, well, I'm going to take a gap year. Okay, you're going to take a gap year from university, and oftentimes folks would travel. Well, never mind international travel, domestic travel is difficult. So you're not going to really do much in the way of traveling. And again, the job market is relatively weak. You may be able to find a job to make ends meet, but that's not moving forward in your life. That's not moving forward in your career. Again, and these are going to be decisions everyone is going to have to make on an individual basis. And I think the more of a self-starter you are, the more mature you are, the more you can sit in front of a computer and understand that this is a slightly different learning environment, the better you will take to law school and the better you will do once you arrive here.
thank you for that. And I know that this isn't really the focus of our conversation, but we did get a question in the chat on admissions. I don't know if you can speak to anything admissions or applications. Somebody was asking about a personal statement question. Is that a topic you'd want to cover, or?
I'll tell you, I've never been on the admissions committee at my law school. I can tell you that we certainly read everything the applicants submit, and personal statements, I think, can be, I shouldn't say I think, are an important part of the application. To put into context, if somebody scores in the 95th percentile on the LSAT, then you're going to go pretty much wherever you want to for law school. And the personal statement is going to be of relatively unimportant at that point. Relatively, I don't want to see that it means nothing, but it's relatively unimportant. But for many people, their LSAT score is someplace more in the middle. And when you have an LSAT score in the middle, your personal story, why you wanted to come to law school, what you've done to get to this point in your life, the hurdles that you had to get over, the things that you had to get through in order to be in this place in life, those are meaningful to us, and we take them very, very seriously. Suffolk was created it was over 100 years ago now, by an individual who felt like legal education was too elite. That we were in a state with Harvard, and Yale was down the street from us, and only a few hundred miles away. And the school was built on an evening model so that we could accommodate people in the working world, the immigrant community that was moving into the Boston area. So personal stories have been and will be important to us whenever we're engaging in the admissions process.
Thank you. Now that we've had our obligatory discussion of how COVID impacts everything,
Sure.
I'm wondering if we could turn back to the law school prep side of things.
Sure.
We discussed a little bit about, I brought in the LSAT's relevance to what you were discussing about problematizing things, complicating things more, maybe overcomplicating sometimes. But I think one thing you said really stuck with me, which was that you can't cover every fact pattern. There's just infinite possibilities in terms of how things unfold in the real world. We create new laws to address new things as they come up.
Sure.
But the idea is all about the general principle, right?
Yes. Yep.
General principle. So I'm thinking of LSAT principle application.
Sure.
Now, with that in mind, somebody who has not even yet been to law school, maybe they've taken the LSAT, maybe they haven't. What might they be thinking about now in terms of maybe some light reading to be doing, or if they're about to start in a couple of months, maybe some more serious reading, aside from your book, of course, and you could talk about your book as much as you like, please.
Sure.
but
Sure.
give,
Yeah, I
give
might
us,
sneak it in there a couple of
yeah,
times. Yeah.
give us all the details on that.
Yeah,
But
sure.
I'm just wondering, what should they be thinking about without having actually started classes yet?
Sure. So a couple of skills that you can work on improving, and there's some of those somewhat rudimentary here. We were just talking about this on the academic support listserv. Typing skills. Everybody before. I'm a dinosaur, so back in my day, we actually took typing classes. Um, that's an essential skill. Almost everybody does their examinations on a computer now, and being able to type while you're in a classroom, but more importantly, engage while you're in a classroom and stop typing. That's really what students can struggle with at times. You can become a stenographer and you lose the real thread of what's being discussed, but you can work on your typing skills. You can work on your reading proficiency. But in terms of the law, I tend to tell students, we will teach you all the law you will ever need to know once you arrive in law school. I think there's a benefit to books like mine, Succeeding in Law School, others along that line, Law School Without Fear, Getting to Maybe, Who's Monet, books that discuss the law school experience so that you're not blindsided by it. So that when you enter law school, you recognize, hey, there's going to be a Socratic dialogue, and which means the professor is going to we're going to go through a case together. The professor is going to pose a question to me based off of that case. And when I feel like I understand what the answer should be, the professor is going to flip it around on me until I'm painted in a corner and I have no idea what the answer is supposed to be. If you recognize that that's what's going to happen and that there really wasn't going to be a particularly complete answer to that problem, then you don't feel bad at the end of that session. If you don't realize that coming in, that that's what we're going to do, you become anxious, agitated, and feeling like you're failing on a daily basis. And that's not what's happening. We're teaching you how to think differently, how to think in a lawyer way, which means think analytically and understand the ramifications of what you say and what your answer is. One of the simple problems we often will work on, again, as I've mentioned it before, is the tort of battery. And for the tort of battery, you have to intend for there to be a harmful or offensive contact. You have to actually make contact with somebody else, and it has to actually be harmful or offensive in the end. And those words all seem very simple and very rudimentary, but something as basic as contact, well, when you punch someone in the face, great, that's really simple. But if I said to you, I walked up to you and knocked your hat off of your head, is that contact? And you say, well, the hat brushed against your head. No. Putting that aside, is the hat an extension of you? That's a principle that you will learn to work with in law school. And you'll realize, yeah, pretty much all of my clothing is an extension of who I am. So if you touch it, you're touching me. And then you realize that's not what they're going to ask me on the law school exam, because that's too easy. It's going to be, you're driving, you're in a parking lot and someone walks up to your car and starts banging on the roof of your car. Is that car an extension of your body at that moment in time? Is the chair you're sitting in, if someone kicks, an extension of you? Is the wall you're leaning at, if someone punches it, an extension of you when you're leaning against it? Not that there are absolute answers to any of those things, but the idea of taking those basic principles and moving them forward, extending those results further out and reasoning through them, that's really what the skill that you have to master when you're here. And that's not something that you can really do before you come to law school, but you can learn to expect it before you come to law school.
Wow, that's kind of funny. You're bringing me back to something super random that I haven't thought of in years. But back when I was finishing up college, I briefly looked into management consulting. And I learned that one of the questions they ask in those sorts of interviews are these puzzles where there's not really a right answer. They might ask you, how many haircuts are given in the US every year? And if you just answer, okay, well, 10 million, that's not a good answer because you're not giving any reasoning behind that. Whether you give the correct literal answer or not is completely irrelevant. The idea is, what kind of reasoning did you get to? So let's say men get on average a haircut every 6 weeks. Women get on average every 10 weeks. And you could say there's X, this number of women, this number of men, this number of kids. And if you play out all those details and show your work, so to speak, that's a better answer. And so I'm thinking here where the car, the hat, are they equivalent? Are they not? Who's to say?
Right. And I like the words you use there, show the math. You show the math in front of you. I mentioned earlier that folks who have an engineering background, they're used to the rigors of law school. they struggle with the gray in law school because X has to equal something. What does X equal? Tell me what X equals. I can work through it. Give me the formula and I work through it. And that's not how law school operates. X equals infinity. X equals anything. You have to be able to work through the problem and one of the things that we teach our students, and really the first half of law school extensively, is objective reasoning. But you have to arrive at a conclusion, and students struggle with that notion at times, like, well, if I'm being objective, how do I arrive at an answer? It's like, no, those things are not mutually exclusive. It simply means that you have no vested interest in what the outcome is, but you expose the reader to your reasoning, to your thought process. And that's what we do even as lawyers, even as advocates. In order for me to be a true advocate, I need to understand my argument and as well the opposing side's argument. If I don't, I won't know what they're going to say at trial. I won't know what they're going to argue. So I have to anticipate those things so I can counter them in the affirmative.
I love that. And I'm reminded of the idea of like debate tournaments or moot court. And I know Jasmine, who's here with us tonight, she's experienced in that. The idea is that you're playing out both sides so you can anticipate your opposition's arguments in order to better defend yourself against them. And which side you get is somewhat arbitrary, especially in civil law, where the plaintiff, the defendant, like all that is whoever your client is. They come to you, they have a problem. Your job is to advocate for them. It's obviously not going to be 100% on their side. So you have to acknowledge the weaknesses and be ready for them.
Yeah, one of the simple devices we use with students sometimes in the early stages is, okay, now begin writing pretending that you are the plaintiff or the prosecutor. Finish. Now, the same facts, write pretending that you are the defense counsel. Okay, now that you've taken each side, now weigh those alternatives against each other and tell me which you think is the most powerful. That final piece is really where the in-depth analysis occurs. Those first two phases are persuasive analysis. You're trying to convince someone of a position. At the end of it, however, as you start looking at both sides, and eventually you learn to not adopt one side or the other, you learn how to do that more organically. But eventually the weighing process of the alternatives against each other is where you discover that there is a stronger position. It may not be 100% strong, but it is stronger, and you explain to me why that is.
Interesting. So I know it's probably impossible to put numbers on this, but I'm just thinking about it a little bit. On the LSAT writing sample, it's pretty much 50-50.
Yeah.
And it's meant to be that way on purpose so that, for whatever reasons, just to keep it reasonable. But in these cases that you come across, is it like, or that law students are coming across, is it 60-40? Is it 65-35? What does that look like?
Yeah, great question. The answer is, I'll give you the classic law school answer. It depends. And it depends on sometimes the subject matter. I tend to find that contracts professors, for example, create problems that have more specific answers to them, that do have a stronger final outcome to them. In contrast, torts professors and criminal law professors create problems that are, 60-40, 55-45. Now, when I say that they create a problem that's 60-40, it doesn't mean that all aspects of the problem are 60-40. One of the things you learn is, I talked about a battery a few moments ago, that the intent aspect of it may be really obvious, and that it was harmful or offensive may be really obvious. But whether it amounted to contact or not, that's where the meat of the conversation is. So something else that you learn is how to work through the simpler aspects of the problem relatively quickly so that you can spend time on the meatier aspects of the problem and work through those. And those meatier aspects, you might go through the easier aspects of an issue in 2 or 3 sentences, and it may take you 2, 3, 4, 5 pages to go through the one meaty aspect of the issue.
Nice. So it's really drilling down to the core of the issue, the crux of what will make or break the case for one side or the other, and sweeping everything else aside, getting that out of the way.
Exactly. And the difficulty that you can have is understanding that even on the simpler pieces, you have to go through the process, because things often seem simple at first blush. So you have to work through, and I always tell my students, when you were in the paradigm, that one of the paradigms we use in law school for organization of an answer is IRAC. State the issue, state the rule, analyze it, and come to a conclusion. And I tell them, when you reach the analysis phase, it's actually 2 pieces. Analyze one side, analyze the other. And as early as orientation, I tell them is, you should presume that there is an opposing argument. It doesn't mean that there's always going to be one, but presume there is one until you look at it carefully and say, you know what? There are no facts that counter this. There is no reasoning that counters this. This issue is as simple as I thought it was at first blush. Okay, now let's move on to the more complicated aspects of the problem.
I love it. Wow, this is super interesting. And I've had these sorts of discussions before, but I feel like we're really getting into the meat of this here. And so I'm wondering, again, aside from reading the books, aside from reading Succeeding in Law School by yourself, what else should students be doing, let's say a year out, and then specifically a few months out to really get themselves ready?
Yeah, so if you're a year out of law school, I wonder if you've taken the LSAT yet. If you're a year out of law school, the LSAT is, I like to say, an unfortunately high stakes aspect of the admissions process. There are schools that are talking about going away from the LSAT. Not many have at this point. So it is unfortunately an important aspect of the process. So spend a lot of time preparing for the LSAT. Do programs like yours. There are other programs, but do programs like yours where you are working through the problems, where you're working through them on a regular basis. That doesn't change by the time you come to law school either, by the way. That the final stage of the study process on a weekly basis is reviewing what you've just gone over. And whether it's in law school or before law school, that means working through problems. Okay, I think I know this. I think I know this idea. Let me work through 10, 20, 30 different problems to see whether they can stump me. And that's what you would be doing at the preparatory phase before you take the LSAT. If it's only a few months out of law school, the only advice I would have there again is pay careful attention to everything that we are sending you. Again, I'm a dinosaur, so I read emails. The younger you are, the less attention folks tend to spend on emails. But we view email in our institution as a formal mode of communication. And as lawyers, there is nothing in our emails that is fluff. It is all there to be discussed. And too often, my answer to a student inquiry is, look at paragraph 2 of the email that I sent you that you're responding to. That's where the answer is. Because there'll be a lot of information about the enrollment process, about book buying, about orientation. For example, expect orientation is actually the beginning of law school. In fact, I would love to dispose of the word orientation entirely and say, no, those are your first days in law school. We're going to teach you content. Yes, we'll let you know where the lockers are and where the cafeteria is, but we're also going to give you important skills, or begin the process of teaching you skills that are essential to your first days in law school. So make sure you're paying attention to all those law school communications so that when you arrive, you're ready. Some of your professors, a few weeks out, will make available to you your initial assignments. Great, do them. I mean, know them weeks ahead of time, prepare them. Too often we have students enter class and they get called on the first day of class and they're unprepared. I thought we were only going to go over the syllabus today. Well, why would you think that? Because we've sent you multiple communications saying, no, today's the first day. I expect you to have read 50 pages today, and here's what those 50 pages are. So make sure you're paying attention to all those communications you're receiving from your law school professors.
That's important advice. Yeah. Email has kind of dropped to the back burner as like socials become more important. So I feel like if it was in a Facebook message or an Instagram post, people would be more likely to see it sometimes.
Yeah. I was actually discussing this with my wife earlier today, and I feel like I don't think Facebook's even the correct option because that's too old at this point. Mm-hmm. Although some of my colleagues use that with bar preparation, they use Facebook because it's a little bit more of social messaging, and it's an easier way to post content as well to some of the other platforms that are out there.
Right. I like what you said earlier though about like doing dozens of problems, like doing 10, 20, 30 problems to see the different iterations, because you see variations on the same ideas, and you also see things repeat as well. So even if you didn't catch it the first couple of times, by that point later, you've got that method of reasoning down. You've got that fact pattern and principle application down, so that when you see it again, you recognize it, even if on the surface, it might appear a little bit different with a different topic or be in a different context.
Right. I mean, I've mentioned a few times, we can't teach you every fact pattern that you're ever going to encounter as an attorney. But the more problems you do, the more that you recognize recurring scenarios. So when my students take their midterm examination in civil procedure and they come to talk with me about how much they struggled with it, I said, hey, I bet on your civil procedure examination, that someone was living in state A and they went to a different state and they were making some vague statements about how much they liked living there, being there on vacation, or maybe they were a long haul trucker and they were thinking about moving there. Did that happen? Like, oh my gosh, how did you know that? Because an aspect of civil procedure is domicile. Domicile means the state that you are residing in. And the only way for us to test whether you truly understand that concept is for you to have a person who shifts between different states. So the fact pattern is always going to have somebody going from state A to state B. How they go there, that's where all the differences are going to be. But that it's going to happen, that you can prepare for that and understand some of the analysis you're going to have to bring to bear before you ever enter the examination. That's the analysis you have in your pocket that you're ready to go with. And it's not unique to that particular problem. It occurs in discrete areas throughout the law. There are recurring scenarios that happen over and over again, and there are only a finite number of ways that we can test those ideas.
Interesting. So there are a handful of fundamental concepts that are consistently tested, and the details may vary from exam to exam, but overall, these are just recurring issues like interstate commerce, interstate travel, things
Right,
that you
exactly.
can expect will become issues in the US where we have 50 states and lots of interaction between them.
Right, right, and you know, once you become proficient at these skills, you realize that each rule that you learn has its breaking point. You know, when do I know absolutely it's going to apply? When do I know it's absolutely not going to apply? And where is it in the middle? And that's where we're going to ask you the questions. So once you recognize that, then the fact patterns become more obvious. The thing we were talking about a short time ago about the idea of contact for a battery. The case that we read that in is someone holding a tray in a cafeteria line. Once you recognize that that's an idea that is where the tension point is in that rule, then you will always have your eyes open for somebody holding on to something, wearing something, or grabbing onto something that is grabbed from them. And you recognize that idea well in advance and have at least a partial answer, again, in your pocket, ready to go for that concept.
Nice. I love that. Yeah. I'm thinking back to parallel reasoning, principle application.
Sure.
Same
Yep.
ideas. Yeah. Same ideas. Extracting that general principle, applying it to a different situation. It's not about trays. It's
Yep.
not about the cafeteria. It's about holding something or grabbing something. And then
Right.
contact
Exactly.
that doesn't hit your skin, but still hits something that, as you said, an extension of you.
Right. You know, what's the central idea? What's the central notion of that idea? And then what I call it with my students, result extension. Take the result, extend it forward, and extend it forward to the point where you no longer are sure how it should be resolved. That's going to be one of the questions on your exam, I guarantee you, where you're not sure. But then remember what we talked about. That lack of certainty is fine, and as long as you reason through the problem, expose me to your thought process, let me read it on the page, and arrive at a well-reasoned conclusion. Great, that's the A answer.
Nice. So that ambiguity is where everything interesting is going to happen.
That's right. That's right.
Nice. I love it. So what else haven't we covered? What else does everyone need to know?
Let's see, what else do students need to know? I'm actually looking at some of the notes that I had prepared here because you always have to get prepared before you do anything like this. You know, again, just going back to some aspects of the some of the negative aspects and positive aspects of what the changes have been since the virus has occurred. One thing that had occurred to me with a lot of our students saying said this to me, that they were no longer worried about their commuting time coming into law school. So if you're in a law school that's going online or a law school that's going some sort of hybrid system, if you live in a urban area, it can easily take an hour plus to get into school. Suddenly we had these students who had 2 hours plus every day. And that was an enormous boon to them, assuming they use that time efficiently. That's a really important, you know, an important small positive. There aren't a lot of positives as you're going through a pandemic, but in relation to law school and in relation to the experience that our students had last spring, that was something that they commented on positively. That not being in the building was challenging at times, it was isolating at times, but it also meant that they had more time to work through their ideas.
Right. And that's very true. Saving on commuting time, enormous benefit.
Yeah.
Or at least potential, no question about it.
Yeah. You know, if there was one other thing that I would like to talk about, and we've touched on it a little bit, this idea of result extension. And one of the things I talk about in my book, Succeeding in Law School, is when you're in classes, when you're in law school, not classes for a moment, when you're in law school, understand that the process of studying for examinations begins the first day that you're there. Do not believe that you're gonna read the material in the syllabus, show up to class, and study for 2 weeks before the exam and get an A. That does not happen. You have to treat the first day of classes as if the exams are happening the next day. To do that effectively, I like to break the study process down to 3 separate pieces: pre-class, during class, and post-class. And pre-class, all you're really doing is the reading. What is the focus of this case, or at least what do I believe the focus is of this case? Let me take down some notes on the material that I've read so that if I'm called upon, I can be reasonably intelligent and engaging in a dialogue with my professor. Now I'm in class. Your job is not to be a stenographer. Your job is to engage and pay attention. Type less and pay attention more. And pay attention to what you thought the answers were from the cases and how you now have to modify what you believe that answer was based on the new information you're receiving from the professor and from your classmates. I like to say, when a professor poses a problem and you talk about it for 25 minutes, that entire discussion is the answer, that entire thing. And you have to think with the class along there. The final stage of the process is post-class review. And it's something that students should be engaging in when they're in law school on a daily and certainly at least a weekly basis. Take all the notes that you've written, review them, and now distill them down. What were the essential aspects of the material? What principles did I understand? What hypotheticals did the professor give us that I thought I understood when we were discussing them in class, but now as I'm looking at them again, I don't know how they arrived at that conclusion. I guess that means I have to go back and do some additional research. If you're not looking at secondary sources to develop a deeper understanding of the material on at least a weekly basis, believe me, your classmates are. So that's where the learning truly happens, not before class, truthfully, not even during class. It's after class is over when you have a time to take a breath and think more deeply about everything that you've just gone over, and you start distilling it down. That distillation process we call creating an outline. So at the end of the semester, you have created your primary study tool that you will be referencing back to consistently in the last weeks before the examination.
That's a super useful breakdown. Somebody had just asked right before you started on that, somebody asked about expectations of students should have of professors and vice versa, but it sounds like you just nailed that in depth. I love what you're saying about the work just beginning really when class is over.
Absolutely.
You've got to do the work on your end. Class is just only the beginning really.
Yeah. Become your own best teacher.
Yeah. Love it. All right. So this has been a fascinating discussion, Herb. I really appreciate your taking the time. The book is Succeeding in Law School. Anything else folks should know about in terms of where to go for more?
No, as far as the book is concerned, Carolina Academic Press. I believe if you go to the website there, you can get some sort of discount on the book. A number of schools actually do require it for students who are entering. It's suggested reading at my law school for entering law students. If it's not, again, I'm not just hawking my own book. There are a lot of other materials out there, but I would recommend taking a look at something that just doesn't talk about law school examinations. That's the end of the process. Something that prepares you for those initial weeks of the law school experience.
Fantastic. Well, I'll definitely recommend folks check it out, Succeeding in Law School. I'll link to it for everybody after this on Carolina Academic Press, Amazon, wherever else. Definitely encourage folks to check it out. This has been so useful. Again, I appreciate your taking the time.
Oh, it's been my pleasure, Steve. I always enjoy talking about these things. Thank you very much.
My pleasure. Take care. Have a good one. Bye, all. Thanks
too.
for the great
Bye-bye.
questions. Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I'll wish you all the best and take care.